So I think even with that money, Section 327 might be invoked. So concealing, disguising, converting, transferring, removing, potentially for the firm. Okay, Alison, let's pivot back to our fee earner and his dilemma or her dilemma. Um, we've seen that the fee earner so far is comfortable with the £75,000 from Mr. A's savings, but much less so the £25,000 from his overseas business. Could you use this contrast to explain, in very simple terms, please, the principle of fungibility?
Always a tricky one, but it's basically that by mixing funds, you're tainting the money. So you've got, if you put the two lots of money together, and you've got 25k, which you think is criminal property, you've got 75k, which you think is okay. You put them together, and how can you tell which pound is which?
Yeah.
So it's tainting. It's the best way to describe it.
Yeah, that's quite clear. Okay, very briefly again, I know we could be going down a rabbit hole here. Could you please tell us that there's the exceptions on the ECTA, the Economic Crime and Corporate Transparency Act, in relation to exiting and paying away funds?
So there are two. There's the mixed property and also the paying away. Uh, yes, look at them, but frankly, and it says this in the LSAG guidance, they're not really of much use. Um, it's just it will. I've given advice on this actually fairly recently, and yes, okay, you've got £3,000, that you could pay away when you're exiting a relationship, but I wouldn't rely on it. It's
Mm,
just not clear enough. So yes, we've got two new exceptions, uh, but the reality is they're not really very helpful. And one of the things just to stress here is the importance of looking at the Legal Sector Affinity Group guidance or LSAG
yeah.
guidance. Um, you should basically read it like a novel. So MLROs, MLCOs should be familiar with, the whole document. I've read it. I couldn't tell you exactly what's on page,
Yep.
134, but you need to be really familiar with it. Need to know where to go to check out the good practice and the regulators' expectations. And bear in mind that previously the guidance and the practice notes that preceded it were very much an interpretation of the law.
Right.
The LSAG guidance raised the bar significantly, and we now have a whole set of obligations um, as a result of the guidance and a whole set of expectations which are much more challenging to comply with.
Thanks, Alison. That is an important point. So I have a quick tip on that actually. When I used to go out to do inspections, AML inspections for the SRA, um, I don't know, MLCOs used to try and impress me by having a printed copy of the LSAG guidance in front of them, which most of the time they probably haven't read, but they just wanted me to see that they had it. But my quick tip is if you are looking for anything quickly on the LSAG guidance, you can do a quick Control F. So if you're looking for something specifically in relation to, I don't know, source of funds, if you do Control F and type in source of funds, it would highlight every section that source of funds is mentioned. So you could go, obviously, don't just go read where it says source of funds, look at the text that precedes it and the text that comes after, so you can have the context in which whatever you're reading has been said. But like Alison said, I've read it, but I couldn't tell you what's on page 134 either. But at least I know if I wanted to get some information about something, I can find it. So thanks for that, Alison. Back to our case study. So quick recap again. Up to now, our fee earner has been trying to piece together the story behind Mr. A's funds. When it comes to his £25,000 from his business overseas, the gaps in the evidence are starting to feel quite worrying. And at the stage, the fee earner begins to suspect that the money could be linked to criminal activity. And so that's where we've gotten to so far. If the fee earner goes to the MLRO and the MLRO decides the risk is too high and decides they're going to withdraw from the transaction, Alison, what report can or should the firm make?
So it depends on what the firm is going to do. I'm just going to get rid of that. Is the firm going to, if the firm decides that there is a big enough gap and they're not going to carry on acting, so then they withdraw from the transaction, they sack the client, and then decide, well, actually, I need to make an information suspicious activity report. Back to my earlier example, the two
Yeah.
clients being investigated. Um, there are situations, not this one, I don't think, but there are times, particularly if your concern is about the other side rather than your client, where actually you may decide that you will carry on acting, uh, uh, but make a report, a SAR, suspicious activity report, and ask for consent. So, for example, if you were daft enough, frankly, to want to do something with that 43 grand
Mhm.
and return it to the client, which would be very silly,
Yep.
then you would make a report and say to the NCA, please can I have consent, defence against money laundering, to return that money to the client. I think in the circumstances, the NCA would say no chance. But it's really just to make the point that you
Yeah.
can, uh, in certain circumstances, carry on acting. This would not be a good example, but there are other cases where you do make a report, you carry on acting, and importantly, you make the report on behalf of yourself and the client
Hmm.
because you need to protect the client who is potentially receiving money, dirty money from the other side.
Yes, that's a great point. I'm going to pivot back to the DAMLs, to the Defence Against Money Laundering SARs in a second. I just wanted to, I had a follow-up question in relation to the information SAR. Can the firm still submit an information SAR if it was the client who withdrew from the transaction and decided they didn't want to proceed any further?
If the firm or if the MLRO has suspicion, then it doesn't matter who stopped acting, whether it was the client who withdrew. In fact, in some ways, you kind of lift the level if it's the client that's withdrawn, because that
Yeah.
suggests that the client is starting to realise that uh, the firm or the MLRO is suspicious about them.
Yeah. Yeah, absolutely. And then another point I wanted to make on the DAML SAR, the Defence Against Money Laundering SAR, is um, just because the NCA has provided or granted consent um, does not mean that it's a green light to proceed with the transaction. So the NCA's consent simply means that the agency will not take action under POCA. It does not confirm that the funds are clean or that the transaction is risk-free. The firm essentially still has to, consider its own risk appetite, the regulatory obligations, and the potential for reputational damage before deciding whether to proceed or not. So
Absolutely.
Alison, whilst we're on the topic of DAMLs, let's briefly touch on tipping off, which you did mention earlier. If you could explain to us what it means to tip off a client.
So, well, tip off a client or another person.
Or another
Um,
person, yeah.
you need to be careful about both. So, take our example. You have a suspicion. The fee earner has made an internal report to the MLRO. So the fee earner is suspicious. The MLRO will make up their own mind. They have personal liability as to whether they report. And if the client then turned around to the client, Mr. A, and said, "Oh, Mr. A, just to let you know, I've made a report to our MLRO." Well, that would be tipping off, and that would be pretty silly. I mean, just look at it outside of the legislation, because what that would do is risk prejudicing any future investigation that comes as a result of the report. it opens up the client to say, "Oh, whoops, I better go and destroy evidence." Well,
Yeah.
that's going to prejudice an investigation.
Mhm.
And similarly with the other side, "Oh, Mr. B, we've made a report about you." Um, Mr. B goes off and destroys evidence. But one of the things to be aware of is that you have the tipping off where you actually say, it's we've reported, but you also have the situation where the you become suspicious that a report has been made,
Mhm.
and this is where you are acting and you've been involved in a transaction which has been going at high speed for quite some time, and then suddenly it all goes quiet. The
Yeah.
other side, stops returning your calls,
Yeah.
uh, and you're suddenly thinking, well, what's going on? And there is a real possibility. I mean, obviously, the other side could just be, useless, but there is a real possibility that actually what's happened is they've made a report, and they are waiting the 7 working days to see whether or
Mhm.
not they get a defence against money laundering uh, or um, or not. And bear in mind that you have the 7 working days, which can then be extended by the moratorium period of 31 calendar days.
Mhm.
Um, Normally, if the money is in the UK, then you'll get the uh, defence granted within those 7 working days, or the NCA will let the time run out, in which case you have deemed consent. Uh, but if the money is going overseas, then the moratorium period can be used and it can be extended. And going back to your earlier point, it's worth picking up about the the fact that a defence does not mean that the transaction is risk free. It is then for the firm to decide, well, yes, we've got the defence, but actually, we're not comfortable carrying on.
Yeah.
You might stop acting at that point. So it's important that firms understand that it is not risk free. It's not a, yes, you're absolutely fine. It's only a defence in terms of money laundering.
Yes. Thank you, Alison. That's a really clear explanation of why legal professionals have to be so careful. So let's take our case study a step further. I'm going to throw in a curveball, Alison. What if Mr. A, our client, was suspected of being involved in something which is a crime in the UK, but not a crime in the jurisdiction in which he's continuing his business? Um, what I'm really asking about is if you could explain to us what the Spanish bullfighter exception is, please.
So the Spanish bullfighter exception, which I think we all love, is one that was introduced by the Serious Organised Crime and Police Act. And basically, if you think about Spanish bullfighting, bullfighting is legal in Spain. It's not legal here. So Mr. A has been a Spanish bullfighter. He has the earnings from Spanish bullfighting, but he wants to use that money in the UK. Well, because of the Spanish bullfighter exception, uh, that's okay because yes, it, bullfighting is illegal here, but it's not illegal where he earned the money. I think you've got to be a little bit careful with this. I was looking at something earlier, um, and I will have to go and do some more hunting because I thought that even with the 12 months, there were some exceptions, Financial Services and Markets and Gaming Act, but I can't find the references at the moment. But if you are thinking about the, using the Spanish bullfighter exception, if you look at section 16 of the Legal Sector Affinity Group guidance, I think it's 16.7 something 4, I can't read my writing, then you go and have a proper read. And again, back to the MLRO point, if you're going to rely on any exception, you want to make sure that it is as watertight as possible and that you have considered all of the elements.
Thank you, Alison. That's very helpful. I'll hunt it down as well and see if I can put it in the show notes for anyone who's interested in using that exception. So let's have a look at the issue of conflicting obligations, and you did mention one earlier. So when a law firm suspects something is wrong, let's discuss which duty takes precedence. So there's the obligation to keep information confidential, but then there's also the duty to report, which takes precedence.
Well, when it comes to the Proceeds of Crime Act, and you need to be very careful here, um, then reporting then confidentiality is overridden by your reporting obligation. And when I say you need to be very careful here, is you in any situation you need to look at what is the relevant legislation. So, for example, because again it's one of my favourites, um, firms get served with um, requests under the Data Protection Act to provide confidential information, and the relevant provisions in the Data Protection Act, which talk about crime and fraud, do not override confidentiality. It's simply a request. So it's really important that firms are aware of that. And the law enforcement do it. The number of times that I got served with a Data Protection Act notice, and I go back and say, sorry, you're going to have to serve me with a production order because your notice is not sufficient to override confidentiality.
Mm. That's really helpful. Then you mentioned legal and professional privilege earlier. How does that slot into that question?
So, whilst confidentiality is overridden, legal professional privilege is not. And so you need to be very careful about the information you provide. And if, again, back to your MLRO to make that decision, because it is a complex area, but make sure that actually all that you provide is the confidential information, not the information which is subject to LPP, unless you think the crime fraud exception applies.
Right. Very complicated.
Exactly. So it's and what was interesting many moons ago was talking to someone who was with the National Criminal Intelligence Service, which was before SOCA and before the NCA, and in relatively early days of the legislation. And she said, we get stuff through which I can see is subject to LPP. We shouldn't be getting that. So
Right.
again, it's very important that firms understand this and don't leave themselves open to a claim for
Mm.
breach of LPP.
Thank you, Alison. This has been such a fascinating walkthrough of this scenario. And if you could give one piece of advice to fee earners handling complex transactions like this, what would it be? I think I know the answer to this because you've said it multiple times.
The first thing is make sure you are familiar with the firm's policies, controls, and procedures, and
Yeah.
you follow them.
Yes.
That includes the firm-wide risk assessment, client and matter risk assessments, CDD obligations, etc.
Mm.
That is the bit where it is your responsibility as a fee earner to
Mm.
actually understand your obligations. But when you're dealing with something that is complex and it's challenging, and you're struggling with it, go and talk to, if you've got one, your compliance team, probably the first port of call, um, and then ultimately the Money Laundering Reporting Officer. Um, that's the person who has the ultimate responsibility for reporting, who's responsible for making sure that you have got um, reporting procedures in place, and is there as the support for the fee earners. And I think sympathy for fee earners who are in a tricky situation, and particularly if the client is a bit challenging, And they might be challenging, not because they're up to anything, but just
Mm.
because they're challenging. We've all had difficult clients. Um, and make sure that you use the support that's there from the MLRO. You know who the MLRO is. That's an important point. And
Yes.
the other point is make sure you attend the training and keep up to
Mm.
date with the training,
Mhm.
because how else will you know what you can and can't do?
Absolutely. Alison, thank you so much for helping us unpack the risks and the responsibilities, the practical steps that firms need to take. And that's the end of this episode. If you are a solicitor, compliance officer, or anyone working in legal risk, I hope today's discussion has given you something practical to take back to your firm. And if you found this episode useful, consider subscribing, sharing it with your colleagues who live in the world of nuance, risk, and razor thin judgment calls. And if you've got a topic you would like me to cover, I would love to hear from you. And thanks for listening to the AML Clinic. Until next time, stay informed and stay compliant.
Thank you.